Welcome back to the program. Sterling Fox with you this first Sunday of April, joined in studio by Joe Murphy and Brian Brook from the personal injury law firm Murphy Battista, LLP, here in Vancouver. Brian, we were just talking during the break. Brian said, well, I'm a big fan of Joe Murphy's, and we've done a bit of radio together over the years, and Joe Battista we've had the Joes out here on one particular occasion. That was a terrific show. But you were drawn to Murphy Battista as a fledgling lawyer, looking around the landscape, trying to pick a firm to land successfully in, and you selected Murphy Battista specifically. Brian, why?
Yeah, I did. Well, I was a pretty particular kid when I was just getting out of law school. I knew exactly what I didn't want to do, and I had a reasonably good idea of what I did want to do. And Joe Murphy and Joe Battista had a shop that did a lot of high-end personal injury work, particularly brain injury work, which I've always been drawn to, even before I knew what it really entailed. And the two Joes had a really stellar reputation in the industry, in the legal community, not just for doing good work, not just for having high-end files and quality clients, but for genuinely and legitimately having a real interest in the welfare of their clients that often went beyond getting them a monetary judgment or a settlement.
Right.
When I was bouncing ideas of firms that I should be looking at after law school off my dad, one of the first things he said is, Murphy Battista does great work, and they take care of their clients. They really take care of their clients. And to me, that was something that really resonated. Everybody wants to find a job that they can use as sort of a mechanism to do good in the world, so that they feel good about themselves, feel good about what they're doing with their lives. And doing something that's stimulating and challenging and rewarding, where you can actually put the client first, try to do something humanly decent or something in the course of your work. It just was an added bonus, and that really was something that appealed to me.
Well, Joe Murphy, you and your partner, Mr. Battista, have established the firm and built the practice on the philosophy of getting your life back. Tell us about that.
Well, Sterling, the reality is that when someone's hurt in an accident, and of course there's different kinds of accidents and different kinds of injuries, the key that every person wants to achieve, they don't want a lot of money. They want to recover. And the reality is, the better their recovery, the better their physical recovery, the lower their financial recovery. But I've never had a client who's regretted doing well, and I've never had a client who was happy to end up with a poor recovery and a large financial settlement or judgment. People want to get better. They don't want to get money. People hate sitting at home as opposed to working.
Sure.
People enjoy working. So what I've learned in doing this for 35 years is that when left to the medical system, the recovery often or sometimes doesn't go very well because the resources simply aren't there. So what we look to do is we look to add in the resources that our clients need so that they can maximize their recovery. So we will, on many cases, hire an occupational therapist who works with the family and with the medical people. We'll hire psychologists, we'll hire various therapists, and we'll try and set up what's called a treatment team so that these people work together with the doctors to maximize the recovery, because that's really in the client's best interest.
Is this standard practice throughout the personal injury law business? It sounds pretty exceptional to me. Brian is shaking his head very vigorously. Not a chance, he's saying, right?
Not a chance. I think a lot of firms are very, very reluctant to throw their own money behind a case where the success of the lawsuit is up in the air, questionable, on really tough cases.
Okay.
It's a high-risk investment for the firm. And a lot of firms just are not prepared to engage in that kind of investment.
And it's also, I would imagine, Joe, a fairly long-term commitment you're making if you're providing ancillary services to injured clients and so on, and you may win an award along the way, but it's pretty safe to bet that that's going to be appealed.
Well,
and so it's not a process it goes away in a few months.
The cases that take the longest to finish, Sterling, are the cases involving children. And if you have a child with a brain injury, and in my experience, you've got to wait till the child's 18 or 19 or 20 before you can really understand what the long-term impacts are.
Right.
And I've had clients, little kids injured, age of 1, age of 2, age of 3, age of 4, and those cases run for years. I think the longest one I did was 18 years from start to finish.
So this would be a child who was injured in a car accident, and the extent of the injuries wasn't really obvious for many, many years.
Yeah, usually a car accident, but there's a number of other ways kids get injured,
Okay.
tragically. But you've got to wait till age 18, 19, 20 before you understand what the long-term impact is. I had a little girl who was injured, brain injured in a head-on collision, age of 4. Throughout school, she did very, very well. She was on the honor roll throughout high school. And when she finished high school, we found out over the time after high school that the best she could do work-wise is work as a cleaning lady. And she could only do that if she went to the same homes regularly. And she could work part-time because otherwise she just got too tired.
Interesting.
So
and this from an honors student, too.
Yeah,
right?
academically she was strong, but when it came time to actually function in the world as an adult, her brain injury robbed her of the ability to do that.
Right.
But it's only by waiting that long that we really got to know that the impact and the losses to her were huge over her lifetime.
What is the law with regards to statute of limitations, to use an American term, Brian? Because it differs. Joe's just going to great lengths to give us an example of how children are dealt with differently in terms of personal injury or brain injury cases. What is the law specifically, and how does it differ in terms of time to file a suit, etc., between an adult and a child?
Sure. The average adult, any adult in the province, has 2 years from the date of a loss or an injury to start a lawsuit.
Okay.
With a child, the law presumes anyone who's under the age of 19 to be an infant. That's what the legal term for it is. If you're under 19, if you're under the age of majority, you're considered to be an infant. The limitation clock, the burning fuse to start a lawsuit, isn't lit until you hit your 19th birthday.
Oh,
and then you've got 2 years from then. The interesting part, Sterling, is a lot of people don't really clue in that they've got that time limit precisely because they've got brain injuries.
Well, I was going to ask you, it must happen more often than not that it takes longer than 2 years to figure out, oh man, I should sue somebody. I'm really messed up.
Absolutely. And where people's ability to take care of their own affairs, including their legal affairs, by starting a lawsuit or consulting a lawyer, has been significantly impaired because of a traumatic brain injury.
Mm-hmm.
You can always argue on a medical basis that the starting of the clock, the lighting of the fuse should be postponed because of that disability. You can't hold somebody with a significant head injury to the same expectations and standards of a person who's otherwise intact in terms of starting a lawsuit, taking care of their own legal affairs.
Okay. Are the courts sympathetic to individuals who missed out on the 2-year time frame because they may not have known about it or may not have been able to put all the facts together and organize themselves?
Yeah, the law says that the 2 years for an adult doesn't begin to run until they're able to manage their affairs. So if you have someone injured and is in a coma for 6 months,
Okay, sure.
the running of the 2-year time limit or fuse, as Brian said, doesn't start for 6 months. But more often than not, you get someone who's walking and talking. The reality is they're not functioning well, but they appear to be functioning well. And
Right.
those are the cases that are a dilemma, because invariably the insurance company on the other side is going to say, well, listen, if they didn't start the lawsuit within 2 years, they've lost the right to make a claim.
Right.
And they were just fine. And those are the tough cases.
And so do judges, it's not cut and dry, though. Do judges deal with this, Brian, individually on the merits of each case? It can't be just black and white, can it?
Absolutely. I mean, if you're in a coma for a year and a half or something, that it's pretty self-evident that somebody who's unconscious and is in a coma can't be expected to manage their own affairs.
Well, I'm thinking of that the race driver Schumacher who banged his head in a ski accident, and he's been in a coma ever since.
Yeah.
And so again, here's a person who's incapable of doing anything.
Absolutely.
So when he wakes up, that's when the clock starts ticking on the 2-year statute of limitations?
I would expect that Mr. Schumacher, given the severity of the injury he sustained, is going to have considerable difficulties even when he emerges from
Sounds
this
like
coma.
it, doesn't
and,
it?
Yeah, and everybody's hopeful that some of the positive signs he's showing are going to materialize and progress to the point where he's up and at 'em.
Mm-hmm.
But I would expect that the sort of deficits he's going to have would keep that limitation clock being postponed.
I was wondering, Joe, how do you, and you know, we were talking about that first interview in which the client, the potential client,
Yep.
accompanied by someone, has a chance to check you out, and you do, of course, exactly the same thing. Is this a case that we might accept and act for this client? When that meeting takes place and you decide, okay, this is a case that we'll accept this case. But clearly, you know, having made that commitment, this is not going to be easy or short term. This is, what are your criteria for those sorts of big decisions, Joe? Because you commit a lot of resources, and to say nothing of time, to a case.
Yeah, the criteria is sort of varied. Number one, you want to make sure that there's a case that can be proven you can win.
Right.
Someone's going along, walking on their own, they trip over their feet, fall and hit their head, there's probably no case there.
Mm-hmm.
So we look at what the prospects are of succeeding. We look at the size of the claim. We also look at the client. And over time, you develop a skill of sorting out clients that you can work with and clients you can't. Sometimes you get in the first meeting a sense that the client will never be satisfied regardless of what you do. And there's no point acting for a client if at the end of the day everybody's unhappy. I was met with a fellow once 6 months following an accident. He appeared to have had a concussion in the accident, and he came into the meeting having done all sorts of research on the internet on concussion.
Okay.
Well, I didn't take that case because clients with concussions don't get on the internet and do research.
Ah.
So that was a red flag.
Interesting.
If I get into a meeting with a client and don't think the client's being candid with me, then I'll be reluctant to take that case. If the client's got a head injury, I expect that they're going to be reluctant.
Of course.
Or they just don't understand things. So it's a real mix, and I'm sure Brian will agree with me. Over time, we become more skillful at picking the cases that we think we can do a good job, and we think the client at the end of the day will be happy with.
No, I agree absolutely. Over the course of years, you do develop a sense of things that should cause red flags to rise up in front of you.
Of course.
And some features and things you look for as being the hallmarks of someone with a real head injury. And it, after years, and I think Joe is probably in the same boat as well as a number of lawyers in the firm, you can almost pick the cases where you say, if I send this person out to an MRI of their brain, I would give you better than even odds that something's going to pop up in terms of positive evidence of a brain injury, even if it was missed by the ER. Mm-hmm. The way people present in terms of people who do have deficits and presentation features that are very consistent with a head injury are as distinct and identifiable as people who present with stuff that should be raising red flags. And another example is you have someone who comes in complaining of a significant brain injury. They tell you they have an inability to concentrate and focus. They can't organize or multitask. And then they present you with a 60-page cross-referenced multimedia sort of spreadsheet cataloging all of their symptoms over the course of the last 8 months.
Right.
And you realize something doesn't quite match here.
They're doing everything but a PowerPoint presentation.
Well, more or less, yeah. And things like that. The people are probably well-intentioned, but to lawyers who've been in the business for a while, you see those things as raising red flags.
Well, exactly. Now, we need to take a break here, but Joe, just follow up on what Brian was saying. Now, clearly, there's a lot of money out there in insurance land, and it's pretty tempting for more than the odd individual to try and game the system to their own advantage. Do you have people from time to time who show up and figure, oh, well, I'll bring these guys in and we'll scoop a bunch of money from ICBC. Take them for a ride.
Sterling, we have enough well-deserving, valid clients that we don't need or want the people that are there to try and scam
No,
the system. So we try and avoid taking the case in the first place.
But do you see these people anyway? This is my question.
Oh, we see everyone at the first meeting.
Yeah,
the odd one we'll screen on the phone and say we can't help you.
Right.
But normally we want to meet to get a real sense of this person. It's far better sitting across the table from someone than on a phone. So we usually go to the meeting, and oftentimes we'll make house calls. If people can't come to us, we go to them. And we've had cases of people around the province who phone and aren't in a position where they can come to Vancouver.
Of course.
We go to them.
Oh, okay.
We go to them. Kamloops, Kelowna, Fort St. John. We go. I call it house calls.
Right. But there are those red flag moments, aren't there, Brian?
There are, but I mean, we try to have a reasonably good relationship with the frequent flyers we deal with at ICBC and other insurance companies. And in this business, it's like the old saying in life, it takes a lifetime to build up a good reputation and one stupid mistake or decision to blow it irrevocably. In this area of practice, that holds true. I've, and I think most of the lawyers I work with make a point of telling the insurer and the guys we see, the frequent flyers, you don't have to really worry too much about screening out and spotting the fakers and the BSers in our file list, because we triage, we vet those people out in the first meeting or two. You know, my job is to make sure that everybody who I bring forward as having a claim is on the level, is virtuous, honest, and righteous by virtue of being my client.
Right.
More
makes
or
it
less.
a whole lot easier to defend, doesn't it?
It makes it a lot tougher to defend, because where are all the fakers? Where are all the BSers? How are they so good at hiding these people?
Sure.
The reality is they don't get very far past the front door.
All right. Our guests, Joe Murphy and Brian Brook from Murphy Battista, LLP, here in Vancouver. Personal injury lawyers, both. This is The Law Show on AM 650. Lots more still ahead, too. Stay with us.